Hi everyone, so today we would like to present a case regarding our topic which is pure economic loss. So our group chose case L3 Architects Sendirian Berhad against PCP Construction Sendirian Berhad and another appeal. So let's start. Firstly, let us know the fact of the case. So the facts of the case is the plaintiff was appointed as the main contractor for a project known as Cadangan Pembangunan 1 Blok Perdagangan 29 tingkat yang mengandungi 22 tingkat pejabat, 1 tingkat kemudahan, 5 tingkat podium letak kereta, 2 tingkat basement tempat letak kereta dan 1 tingkat mechanical di atas lot 41096 Jalan Ahmad Damai, Bukit Petaling, Kuala Lumpur. The defendant was the consultant architect contracted by the developer Leap Modulation Sendirian Berhad for the said project. So basically, the defendant was an employer for the developer. The phrase "the architect" in the condition of contract should mean the defendant, according to Article 3 of the Articles of Agreement between the employer and the plaintiff. The defendant's powers and responsibilities as a consultant architect for the project include, among other things, checking the plaintiff's progressive payment claims, certifying the sums that must be paid, and certifying and issuing payment certificates in order for payment to be made and released to the plaintiff for work performed by the plaintiff. The plaintiff claimed that the defendant has a professional obligation and duty under the law to the plaintiff that all of the architect's power and responsibilities, particularly in relation to the certification and issuance of the interim payment certificate, must be exercised in accordance with the terms of PM contract and duty of care in executing its right and responsibility as an architect, because it is fairly foreseeable that if the defendant fails to do so, the plaintiff will suffer a significant loss. So the plaintiff claimed that the defendant was negligent in exercising its powers and obligation as the architect for the project, including negligence in certifying and issuing interim certificate No. 19 in violation of the PM contract's express term. So the interim certificate No. 19, which was certified by the defendant as the architect, is said to have caused the plaintiff serious loss and damages. And the plaintiff claim against the defendant is for damages in the amount of Rn 750,000, with general and aggravated damages to be determined by the court. So that's all for the fact of the case. So let's move to the issue.
Now, one of the issues that has been raised in this case is whether a consultant architect appointed by an employer in a construction project owe a duty of care to the main contractor to ensure that the payment certification issued is accurate and valid. In this case, the argument from the plaintiff plead that the defendant has the professional obligation as an architect, has the duty of care toward the plaintiff, that all power and responsibility, particularly in relationship to the certification and issuance of interim payment certificate, as it must be exercised in accordance with the terms of the agreement and condition of building contract 1998. Now, the defendant has a duty of care in exercising its power and responsibility as an architect, because if it fails to do so, it is reasonably foreseeable that it will cause a serious loss to the plaintiff, that in this case, the defendant business or property interest. However, for the defense from the defendant admit that it is the duty bound to ensure that all the matter. However, the defendant also strongly denied that other allegation that was statement in the claim, which is SOC claiming that the validity of interim certification number 19, which was actually dated in the 19th of January 2016, was considered in adjudicating proceeding between the plaintiff and the employer, as well as in the plaintiff's application before the High Court for enforcement of the adjudication decision under Section 28 of Construction Industry Payment and Education Act. Now, if we take a look into the court decision, the Court of Appeal held that it was bound by the decision of the Federal Court in the view of esteemed Sindhian Berhad and Binapuri Holding Berhad that a failure by an adjudicator to consider defences amount to a breach of natural justice. Since the adjudicator refused the jurisdiction to hear the set of claim in the employer's adjudication response, the award of the adjudication had to be set aside. In the session court judge views, if the defendant does not owe a duty of care toward the plaintiff as the main contractor, it will cause a loss to the plaintiff. Now, in this issue, it is clear that a consultant architect appointed by an employer in a construction project owes a duty of care toward the main contractor to ensure that the payment of the certification is issued inaccurate and valid, and therefore it was bound by its duty of care.
The second issue is whether the plaintiff suffered any pure economic loss. Firstly, when the issue was brought before the High Court, the whole adjudication decision between PCP Construction and Lead Modulation was thrown out for failing to examine the sets off submitted by Lead Modulation in accordance with the Federal Court's case of view of Extim Serdam Berhad and Binapuri Holdings Berhad. As a result, even if there was a duty of care, PCP Construction had not sustained any losses since, as stated in Mortego Serdam Berhad and Architect Muir and Chu Serdam Berhad, and another appeal, adjudication rulings are only temporary finality. As a result, PCP Construction is free to pursue its claim in a final dispute resolution forum such as a court or arbitration. According to the High Court, PCP Construction has not suffered any losses, and until such a claim is pursued and denied in a final dispute settlement forum on the basis of improper certification by L3 Architects. It is also worth noting that IPC number 19 was an interim certificate. During the appeal, PCP Construction brought up the High Court case of Saga Fire Engineering and IR Lee Yi Seng. Saga Fire Engineering and IR Lee Yi Seng. The plaintiff contractor in Saga Fire Engineering suffered a number of issues as a result of the defendant engineer's professional negligence. The plaintiff filed an adjudication claim against the project's owner, received an adjudication ruling in its favor, and eventually settled with the owner through a settlement agreement. The plaintiff claimed that he had suffered losses as a result of the defendant's carelessness in certifying. The court determined that the architects owed the contractor a duty of care and were responsible for the damages. Saga Fire Engineering is notable in that the plaintiff and the owner reached an adjudication judgment and afterwards a settlement agreement to reconcile their differences. There was a moment when the loss became crystallized. As a result, the plaintiff's only remaining option was to sue the defendant for carelessness. Despite PCP Construction's effort to depend on Saga Fire Engineering, the Court of Appeal eventually agreed with Aliza Sulaiman's conclusion and upheld the High Court's ruling.
The court decision. Based on the ground of judgment, the session court judge considered the three elements which the plaintiff has to prove in its suit in the tort of negligence. That is, the defendant has a duty of care towards the plaintiff, the defendant has breached the duty of care, and the breach of duty of care has caused the plaintiff to suffer loss. In the judgment of the session court judge, the defendant, as the architect for the said project, has the power to check and certify the payment certificate. She appears to find that apart from owing a duty to the employer, the defendant owe a similar duty of care to the plaintiff arising out of their proximity. In addition, the session court judge stated that in the evidence given in court by defendant witness number 2, he had admitted that the defendant has a duty of care towards the plaintiff. In the session court judge view, If the defendant does not owe a duty of care towards the plaintiff as the main contractor, it will cause loss to the plaintiff. As regards the element of breach of the duty of care, the session court judge arrived at an affirmative conclusion. She held that the defendant breached the duty of care allegedly for rectification works by merely relying on the valuation report prepared by AQS Services Nuremberg without exercising the defendant's own expertise. The defendant's action is also contrary to the agreement and conditions of building contract, private edition with quantities with amendment, which provides that the architect cannot deduct any cost for rectification works from the payment certificate. The session court judge additionally held that the action of the defendant and Perunding Rekamajustrian Berhad in allowing the deduction to be made before the plaintiff could carry out any rectification work as agreed during a meeting attended by representative of the plaintiff, the defendant, AQS Services Berhad, and Perunding Rekamajustrian Berhad is unreasonable and negligent on the part of the defendant and Perunding Rekamajustrian Berhad. As for the element of causation, the session court judge agreed with the plaintiff's submission that defendant's action has the effect of temporary finality. Consequently, the negligence of the defendant has caused the plaintiff to be denied its right to payment under interim certificate number 19 for the completed works.
So that's all from us. Thank you.